All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Actually, that went better than I thought it would, actually.
Really?
This is one of those times it's great to have off camera.
Oh.
She's never seen me. I'm literally biting my tongue.
You just never know.
Jesus is what?
I mean, you use the F word and Jesus in the same sentence. I feel like that's a problem.
She said friggin'.
Well.
This is a serious charge, right?
Yes, sir.
Is this, you're only 18, is this the first time you've ever been arrested?
Yes, sir.
Even as have you had any juvenile cases? As a juvenile, were you arrested?
Yes, sir.
For what?
Unlawful carry.
Okay. And you're asking the court to lower the bond. We're asking for a $50,000 bond. I think that'll be enough, and along with any, if the ankle monitor or any kind of other conditions that the court wants to put on it. You're asking the court to do that, set that, and you think that's a reasonable bond, right?
Yes, sir.
What else were you arrested for as a juvenile?
Is it
Drug case?
possession of marijuana?
Yeah.
Speak up, please.
Possession of marijuana?
Thank you.
And what kind of weapon were you carrying when you were arrested as a juvenile?
Um,
Was it a handgun?
yes, sir.
And that's what you're charged with here is for shooting somebody. Correct?
Yes, sir.
Another question, Your Honor.
No further question.
Any other witnesses?
No, Your Honor.
Mr. Rojas, go ahead.
Yeah, Judge, I understand this is a serious allegation. He's a young offender, and obviously the handgun gives concern, both two different cases with handgun, and I understand the court's concerned with that. He's a lifelong resident of Port Arthur. He's not going to flee. He's doesn't have anywhere else to go. His family lives there. They own property. They own a home that they live in. They're not going to go anywhere. We think if you set the bond at $50,000, that's something the family will be able to make. And if it's at $50,000, they also, I would imagine the court's going to want an ankle monitor on this, and that's something that allows them a little bit of money to pay for the ankle monitor as well. You can set it at $50,000. And that's what we're asking the court to do.
Thank you, Mr. Rojas. Mr. Nichols?
I don't feel that $50,000 is sufficient to protect the community for someone who's been arrested for carrying a gun and is accused of having shot somebody at 3 o'clock in the morning. The allegation in this case is that he and some other individuals followed a young woman home from her place of business where she worked as a waitress and were harassing her, and then ended up shooting her boyfriend who confronted them. So I think $50,000 is quite low and not sufficient enough. Your Honor, I'd ask that you set something much higher.
He was a driver.
So I am taking judicial notice of the court's file, which includes a copy of the probable cause affidavit. The fact, Mr. Trejo, that you've already been arrested as a juvenile, which wasn't that long ago, because you're what, 18 or 17 right now?
18.
18. And I'm not sure what you were doing out at 3:30 a.m. In this situation, but it gives me great concern. Tired of guns, tired of people being shot, tired of it. Jefferson County's tired of it. I'm going to deny the motion. Your bond will remain at $300,000. If it's not already a condition of your bond, I am now making it a condition of your bond, if you make it, that you will be required to wear a GPS monitoring device and be on house arrest if you're able to make that bond. And we'll reset the case for an announcement and get it taken care of as quickly as we can. You can go back with the bailiff.
I don't have anything further, Judge. And before beginning, Judge, I asked the court to take judicial notice of the trial that you presided over some years ago, which gave you obviously a very good insight into the totality of the circumstances and the facts involving this case, and that there were 4 victims of this case. So just ask Detective Coffin, would you state your name for the record?
My name's Frank Coffin.
And were you one of the lead detectives on the case State versus Lively Stratton?
Yes, ma'am, I was.
And that involves the homicide of 4 individuals here next to Lamar campus here in Beaumont, Jefferson County.
Yes, ma'am.
And you were involved heavily in the trial process, preparation, et cetera, and you know what came before the court. Is there anything that you would like to add for Judge West's consideration with respect to a bond being set for Lively Stratton?
Well, Judge, I don't know that I nor Beaumont has seen a murder like this before, where 4 people were gunned down so close to a college campus, so carelessly, so quickly. And I can't recall anything like that before. So I think that in itself states that's a significant event as far as murder is concerned.
Detective Coffin, based on all of your years of training, experience, investigation of homicides, et cetera, do you feel like Lively Stratton presents a significant threat to the community of Beaumont if he is released?
Significant threat.
And do you feel like based on the totality of all these circumstances, there's a great likelihood of his flight if he is released from custody?
I would imagine that there would be, if knowing what he's faced with, knowing the amount of time that he'd already been sentenced to prison, the time that he can be sentenced again, there's no upside to not leaving.
I don't have anything further, Judge, unless the court does from the second.
Oh, you have to ask questions. I'm sorry.
Detective Coffin, you testified at the trial, is that correct?
No, I didn't.
You did not? Did you observe the trial?
I didn't.
Okay.
Well, no, I did not.
So you didn't watch the trial and you didn't testify at the trial?
No.
Okay, so you don't know what happened at the trial?
I was not there for the day-to-day, but I do know what happened. I was here at the courthouse helping prepare with evidence, with witnesses.
But you didn't watch the testimony, did you?
With interviews. I did not watch the individual testimony.
Were you aware that the jury found that 2 of the victims evidently that they didn't convict him of killing the 2 guys with the knives? They convicted the 2 guys without weapons. Were you aware of that?
I'm not aware of the details of how many people or of how he killed each person, no.
Okay. That's all I have.
Anything else?
No, Judge.
All right. Thank you, sir.
Thank you, ma'am.
Ms. Malfino?
Judge, I would ask for a bond in this case that is equal with what the facts of this case are, with the fact that we have 4 homicide victims. I think an ask of $250,000 is extremely low. I think it's offensive to the court to ask for a number like that for all four individuals, maybe 250,000 per individual. So that's back at the $1 million bond that he was originally set on. The court, unfortunately, is required to set bond on multiple murders in Jefferson County on a quite frequent basis these days. And I think something in excess of $1 million is more than a reasonable ask in this case.
Thank you, Ms. Malpina. All right, so taking into account the testimony of the prior trial that I did preside over and argument by counsel, I'm going to grant the writ and set bail. I am going to find that bail in the amount of $1 million is appropriate for the nature of this offense and in line with what I know about the case and the argument. What if there was bond made, there would be a GPS monitoring device required and house arrest. I would obviously, if that bond was made, need to know what that address would be. And then we will get the case set for an announcement and then move it to the trial as quickly as any you guys are ready to do that.
So, Ms. Paul, I received a note that you refused to take a drug test.
Yes, ma'am, because I leaned against the thing. I just finished sneezing back there, and I felt like I was being singled out. I know I have alcohol in my system.
So
from the night before.
So let me explain. If you don't test and let me see what is or is not in your system, I'm going to assume that you're positive,
Okay.
and I will raise your bond for sure, and you'll go to jail.
Okay.
So do you want to take the test and let me see what's in your system?
I don't have anything in my system besides alcohol.
Then go take the test.
I can't pee.
We're going to give you some water.
I just had water.
Then you want me to go ahead and send you to jail?
I don't know. You haven't even finished running down my charges to me.
What?
Running down my charges to me.
What do you mean?
What I was here for, or if I'm going to get a lawyer, and all that.
First things first is I'm ordering you to take a drug test. If you refuse the drug test, then you're refusing a court order, and I'll raise your bond and you'll go to jail. Then you'll have an attorney come visit you in jail, and they'll go over all of the charges. If you want to take
So
your
I can
time,
bond out.
yeah, your bond's going to be raised though.
But could I bond out today? That's what I'm asking because
You don't know what I'm going to set your bond at
I'm
yet.
trying to go to work.
Well, then you should probably take the drug test.
Let's try.
Because the more you refuse to do it, the more concern I have, and probably the higher your bond's going to be.
I'm just worried about getting back to my kids and going back to work because
Then take the drug test. So either there's something in your system other than
I have
alcohol.
something in my system. I
Right.
said that.
You said you have alcohol.
Yes, ma'am.
I'm not worried about that right now.
Maybe some weed.
Take the test. Let me see what's in your system.
Just weed.
Okay. I want to see what's in it. Take the test. And then we'll decide. Just because you test positive does not necessarily mean that I'm going to raise your bond, but we're going to have some discussions depending on what's in your system. So if you want any opportunity today to walk out that door instead of that door, go take the test. Otherwise, I'm raising your bond right now.
I can sit and see if I can pee.
Go try. Justin Wallace with Mr. Lewis. Okay, so you've refused again.
I didn't refuse. I told him that I couldn't go. I didn't refuse, but he said.
There's no way that after a couple hours you can't go a little bit. So I'm going to find Ms. Paul based on your, number one, that you told me that you smoke marijuana. You told the man in the back, the drug tester, that you smoke daily, and that you used alcohol also yesterday, which alcohol's I'm not so worried about unless you're driving, but obviously using marijuana is a violation of the law, which means it's a violation of your bond conditions.
Okay.
And so let me see something real quick. Your current bond that you I need to take a look at probable cause affidavit. Give me just a minute to get you more information about you and your case, and then I'll decide what to set your new bond at.
Miss West, can I say, I know that I'm going to jail today, that's
Mhm.
fine. But I feel like I've been the victim in this and I have the proof. I'm just overwhelmed at this point with the whole situation.
Well,
Because the girl is still harassing me.
have you called the cops?
No, but I have the proof of her going to my job recently. Letters from my job and her job.
All right, just hold on. You're going to need to tell all that to a lawyer. That's You still have that assault down the hall pending?
I have to go to that courtroom for the same person.
All right. So based on the limited information that I have,
Jeez.
I'm going to again find that you violated the conditions of your bond, and in cause number 25 DCCR 1752, raise that bond to $35,000. A condition of that bond, if you make it, is that you have to have a drug patch put on within 24 hours of your release from custody.
Okay.
And obviously, if you get out soon, I'm going to assume that that drug patch will initially be positive,
Okay.
but it should be going down. So it doesn't just test whether you're positive or negative. It gives me an amount.
Okay.
And if it's not going down, then that bond's going to go up even higher. Do you
Okay.
understand?
Yes, ma'am.
If you don't get the drug patch changed every 2 weeks like you're supposed to, some people say, oh, it fell off. And they don't just fall off. Okay. So you need to make sure you have it on at all times. Get it tested when you're supposed to. If you make that bond, go back with the bailiff.
Okay.
For you to say that this is a hindrance to you and an imposition on you does not bode well with me. Hold on. All right. You're on probation for obviously 2 serious felony cases. You have some criminal history, obviously, because you're on probation for an unlawful possession of a firearm by a felon. I get that probation's not fun. I get that you have to do things you don't want to do. That's what happens when you commit felonies. So coming in at that angle is not going to go well. Okay. You've had some issues. You were here and we required that monitor for a reason. And so I'm trying to look back and see, but I'm guessing the reason was that we had some issues with failure to show up, or what was the...
We initially did a judicial review there were some problems with the monitors and getting them to comply. We asked for a judicial review to see if he could get off of it, and he didn't show up for that hearing. And so that's what put him in jail. And then he did get out again. He initially had some trouble keeping it charged and everything, but once it was impressed upon him that this was not going to go away of what he needed to take care of. The only problem is it's not feasible to have somebody that has unstable housing do a monitor, and while he's door dashing after 8 o'clock at night, I've checked his receipts. He does DoorDash. He's got receipts saying that he has, I didn't check every single one, Judge, but I've spot checked, and he is he's doing it. He's going to school, but this monitor is not acceptable way for me to try to supervise him.
Okay. So do you think it would be easier for him that you could actually supervise better without it?
I do.
Okay. All right. And here's the thing. It sounds like, Mr. Joseph, if you had the other time you were supposed to be here, that was probably what was going to happen. And then I got mad that you didn't show up, and I'm going to make you keep the GPS. You see, the consequences just get worse and it could have been better.
I showed up last time. They sent me to a different courthouse in Port Arthur. I had the paperwork and everything. I've been screaming for you for years. I've been doing it.
You've been coming to, you know what court you're supposed to come to when it's my day for you to come to court, because you've been coming since you've been on the probation. So that's not, you know, if there's an issue here where you're supposed to be.
I just followed the last directive order. They sent me to put office and I had.
Who's they?
I had the info.
So here's the thing, things are going kind of well for you. You probably should quit coming up with excuses. Okay? Because it's probably one of my number one pet peeves. It's just to keep coming up. Just take the personal responsibility. Went to the wrong place. Should have asked a bailiff. You know where the 252nd District Court is. You know the judge that's you're on probation for. So I'm going to, it sounds like you've got some really positive things going on and that you were in a bad place and you're working hard to get out of that. This isn't meant to make it harder on you, but you have to follow the rules and you have to show up, stay in touch. It sounds like your probation officer is willing to work with you through all of this kind of turmoil, but you not having a steady place to live. So take advantage of the fact that you've got a good one that's willing to work with you. Make sure you stay in touch with her. Let her know where you're staying. I know that's difficult because if you're changing places, you got to keep telling her, but keep doing all of that. You're going to be fine. Okay. So I'm going to I will allow the order that the GPS monitoring device be removed. That makes it all the more important though, that you stay in touch and she knows what you're doing, where you are and all of those things. Okay. All right. You're free to go.
Yes, she wants to trial. I've conveyed it.
Is the offer, let's see,
Judge, he had previously rejected 15. I re-urged that today. This is their first appearance with this newer charge
right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that.
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? Yes. And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket. Yes. Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you could turn around and try the next one as well.
Yes, Judge. We'll be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
Oh, so it would be stacked, not concurrent?
Well, it would be up to me. So it depends on if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question. It's a court question. Okay. The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right. We'll get it set for trial. Then you can go back with the bailiff.